Governing Texas by Champaign, Harpham, and Casellas. Chapter 2, The Texas Constitution. Why the Texas Constitution matters. The Texas Constitution is the legal framework from within which government works in Texas. Just as the U.S. Constitution is the legal framework for our national institutions, perhaps even more than the U.S. Constitution. However, the Texas Constitution has an immediate and enormous impact on citizens' everyday lives. Its Article 1 guarantees to Texan rights that go far beyond guaranteed to Americans in the U.S. Constitution, addressing numerous specific issues related to Texans' private lives. For example, Article 1, Section 7 stipulates that no money will be appropriated or drawn from the Treasury that benefits a sect, religious society, or religious seminary. Section 7 also clearly lists the condition that the state must meet if it wants to take damage or destroy the private property of individuals. Section 30 provides a detailed list of the rights of crime victims, including the rights to be treated with dignity and privacy in the criminal process, and to confer with representatives of the prosecutor's office. Section 31, now rendered inoperable by a U.S. Supreme Court decision in 2015, defines a marriage as consisting only the union of one man and one woman. Section 33 guarantees Texans' rights, a right to access and use public beaches. One could argue that each of these issues is more a matter of policy preference than of constitutional right. Being placed in the Texas Constitution, however, particularly policy positions take on a protected status because it is more difficult to change a right to enshrined in a constitution than a policy backed only by ordinary statutory law. Given the length and detail of Texas Constitution, the constitutional amendment process assumes a central role in the state's political process. There are some important differences between processes for amending the Texas Constitution and the U.S. Constitution. For example, voter approval is necessary for proposed amendments to the Texas Constitution to take effect. After passage during a regular or special session, the Texas legislature presents to the voters a list of proposed amendments for their approval, whereas the U.S. Constitution has been amended 27 times since it was adopted in 1789. As of 2019, the Texas Constitution has been amended 507 times. The number of proposed amendments and their frequency of approval have varied over the years, although recently most have been approved. Occasionally, amendments deal with structural issues of government in 1979. For example, an amendment gave the governor limited authority to remove appointed statewide officials. A 1995 amendment abolished the office of the state treasurer, placing its duties in the Texas Comptroller's office. In such cases, amendments to the Texas Constitution functions like those to the U.S. Constitution. There are many more amendments, however, that deal with technical problems in the Texas Constitution, reflecting efforts to clean up specific language that has become out of date. In 2007, for example, an amendment passed that eliminated the county office of the inspector of hides and animals, although the office had been effectively abolished with the passage of a new agricultural code in statutory law. The Constitution needed to be brought up to date with the law. Other amendments to the Constitution, Texas Constitution, grapple with pressing policy matters. This gives voters the chance to approve certain policy initiatives directly, something that is inconceivable at the national level. In 2009, amendments were passed protecting certain private property from being taken by the state through eminent domain. Among the amendments passed in 2013 and 2015 were ones creating funds to help finance important water and transportation projects. Without the passage of these amendments, effective public policy in a variety of areas central to the future of Texas would have ground to a halt. In 2019, Texas voters approved a constitutional amendment that prohibited an income tax on individuals in Texas. See this chapter's citizen guide. For more than the U.S. Constitution, in Texas Constitution, it is involved with the nuts and bolts of public policy and must be taken into account frequently by Texas legislators seeking to address problems in new and innovative ways. Here's the chapter goals. The role of a state constitution. Before I get into this, let me go ahead and here are the vocabulary terms. The role of the Texas Constitution. Identify the main functions of state constitution. State constitutions perform a number of important functions. 1. They justify and make legitimate state political institutions by clearly explaining the source of their power and authority. 2. State constitutions also delegate power, explaining which political powers are granted to a particular institutions and individuals, and how these powers are to be used. 3. They are responsible for establishment of local governments, including counties, municipalities, and special purpose districts. 4. They prevent the concentration of political power by providing mechanisms that check and balance the powers of one political institution or individual office holders against another. 5. They define the limits of political power through declarations of rights. State constitutions explicitly forbid the intrusion of certain kinds of governmental activities into the lives of individuals. Since its first constitution, the idea of constitutional government in Texas has been heavily indebted to the larger American experience. 5 ideas unite the U.S. and Texas constitutional experiences. First, political power in both the United States and Texas is ultimately derived from the people. The preamble to the Constitution begins with the clear assertion that it is we, the people of the United States, who ordain and establish the Constitution. Echoing these sentiments, the preamble of the Texas Constitution proclaims that the people of the state of Texas do ordain and establish this Constitution. In both documents, political power is something that is artificially created through the Constitution by a conscious act of the people. Second, the U.S. and Texas constitutions feature separation of powers. The legislative, executive, and judicial branches of government have their own unique powers derived from the people. Each branch has its own corresponding duties and obligations. Third, the U.S. and Texas constitutions structure political power in such a way that the power of one branch is checked and balanced by the powers of the other two branches. The idea of checks and balances reflects a common concern among the framers of the U.S. Constitution and the authors of Texas various constitutions that the intent of writing a constitution was not just to establish effective governing institution, but also to ensure that these institutions would not tyrannize the very people who established them. In this theory of checks and balances, both the U.S. and Texas constitutions embody the ideas articulated by James Madison in the Federalist Papers. NOS I don't know what that means. Numbers 10, 47, and 51. There, Madison argued that one of the most effective ways of preventing tyranny, the concentration of power in one branch of government, was to pit the self-interest to office holders in one branch against that of office holders in the other branches. Good intentions alone would not guarantee liberty in either the United States or Texas. Rather, constitutional means combined with self-interest would ensure that office holders had an interest in preserving a balance among the different branches of government. The concern for preventing the emergence of tyranny is also found in a fourth idea that underlies the U.S. and Texas constitutions. The idea of individual rights. Government is explicitly forbidden from violating a number of particular rights that the people possesses. Some rights, such as freedom of speech, freedom of assembly, freedom of religion, are guaranteed by both the U.S. Constitution and Texas Constitution. Interestingly, the Texas Constitution also guarantees other rights not found in the U.S. Constitution, such as certain victims' rights and the right to have an efficient system of public free schools. This is the terminology for this section. The final idea embodied in both the U.S. and Texas constitutions is that of federalism, the division of government into a central government and a group of regional governments. See Chapter 3. Both kinds of government exercise direct authority over individual citizens of both the nation or a state and a particular region within it. The 10th Amendment to the U.S. Constitution also recognizes the importance of the idea of federalism to the American political system. It reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people." According to the U.S. Constitution, enormous reservoirs of political power are thus derived from the people who reside in the states themselves. Despite the similarities, some important differences distinguish the constitutional experience of Texas from that of the United States. Most important of the subordinate role that Texas has in the federal system, Article 6 of the U.S. Constitution contains the Supremacy Clause, declaring the Constitution and the laws of the United States to be the supreme law of the land. The Supremacy Clause requires all judges in every state to be bound by the U.S. Constitution, notwithstanding the laws or constitution of their particular state. In matters of disagreement, the U.S. Constitution thus takes precedence over the Texas Constitution. One of the major issues of the Civil War was how the federal system was to be understood. Was the United States a confederation of autonomous sovereign states that were ultimately independent political entities capable of secession, much like the current European Union? Or was it a perpetual union of states that were ultimately in subordinate relationship to the central government? The results of the war and the ratification of the 14th Amendment to the U.S. Constitution in 1868 ultimately resolved this debate in terms of the latter idea, an outcome that would have profound implications for the constitutional government in Texas. A series of court cases determined that because of the language of the 14th Amendment, much of the Bill of Rights to the U.S. Constitution applies to the states, a finding that became a dominant theme of constitutional law in the 20th and 21st centuries. The 14th Amendment thus effectively placed restrictions on Texas government and public policy that went far beyond those laid out in Texas' own constitution. Another major difference between the U.S. and Texas Constitution lies in the necessary and proper clause. of Article 1, Section 8 of the U.S. Constitution. Section 8 begins by listing in detail the specific powers granted to Congress by the Constitution. The founders apparently wanted to limit the scope of national government activities, but Section 8 concludes by granting Congress the power necessary and proper to accomplish its constitutional tasks. The net effect of this clause was to provide a constitutional basis for an enormous expansion of central government activities over the next 200 plus years. Drafters of the Texas various constitutions generally have been unwilling to grant such an enormous loophole in the exercise of governmental power, although granting state government the power to accomplish certain tasks. Texas constitutions have generally denied office holders broad grants of discretionary power to accomplish their goals. Finally, Texas' power to establish local governments have no analogous feature in the U.S. Constitution. States such as Texas are sovereign entities unto themselves, deriving power directly from the people in the state through the state constitution. Texas is not created by the U.S. Constitution, although it is subject to it, as we shall see in Chapter 3. Local governments within Texas, on the other hand, derive their authority directly from the state constitution and the people of Texas as a whole, not from the people in the local self-government. For local governing bodies in Texas ultimately means self-government to the extent allowed by Texas legislators under the Constitution. Excuse me. The Texas Constitution, 1836 to 1876. Describe the 7 Texas constitutions and their role in Texas political life. Many myths are I don't know why it's shaking so much. Many myths surround the origins of Texas as a state. Some trumpet its unique origins as independent republic that fought to attain its own independence from an oppressive regime much like the United States did. Others suggest that Texas has a certain privileged position as a state given the way that it entered the Union, or that it reserved for itself a right to break up into separate states. To separate the myth from the reality, it is necessary to understand how the constitutional regime operating in Texas today is the product of a long course of political and legal development in the state. Texas has operated under 7 constitutions, one when it was part of a state under the Mexican political regime prior to independence, one as an independent republic, one as a member of the Confederacy, and 4 as a state within the United States. Each was shaped by historical developments of its time, and following the first constitution, attempted to address the shortcomings of each previous constitution. To understand constitutional government in Texas today demands a clear understanding of the founding of Texas out of its War of Independence with Mexico, and the specific historical circumstances that gave rise to each constitution. The Texas founding. Political scientists refer to the founding as the period in American history when the foundation principles of American political life were established, roughly the period of time from the Declaration of Independence in 1776, though the ratification of the Constitution 1790 and the Bill of Rights 1791. Texas too has a founding period, and on the face of it, Texas' road to independence appears to mirror that of the United States. Like the United States, Texas had a period of discontent with the governing regime that culminated in a Declaration of Independence. However, Texas' march toward independence was much longer and more convoluted than the United States. Here's the term. The Constitution of Cahuilla y Tejas, 1827. Texas was part of New Spain until the Mexican War of Independence, which grew out of a series of revolts against Spanish rule during the Napoleonic Wars. Burdened by debts brought on by a crippling war with France, Spain sought to extract more wealth from its colonies. The forced abdication of King Ferdinand VII in favor of Napoleon's brother Joseph in 1808 and an intensifying economic crisis in New Spain in 1809 and 1810 undermined the legitimacy of Spanish rule. Revolts broke out in Guanajuato and spread throughout Mexico, including its Texas province. Although these rebellions were initially put down by royalist forces loyal to Spain, by 1820 additional local revolts and guerrilla actions had helped to further weaken Spanish rule. On August 24, 1821, Mexico was formally granted independence by Spain. The first federal constitution that Texas operated under was thus the Mexican Constitution of 1824. At the national level, it provided for two houses of Congress, a president and a vice president elected for 4-year terms by the legislative bodies of the states and Supreme Court. Although the Mexican Constitution mandated separate legislative, executive, and judicial branches, no attempt was made to define the scope of states' rights within Mexican Confederation, and local affairs remained independent of the central government. This constitution embodied many of the ideas found in the U.S. Constitution, but there was one important difference. Catholicism was established as the state region and was supported financially by the state. Under the Mexican Constitution, the state of Coahuila and the sparsely populated province of Texas were combined into the state of Coahuila y Tejas, with Saltillo in Coahuila as the capital. More than 2 years were spent drafting a constitution for the new state. It was finally published in March 11, 1827. The state of Coahuila y Tejas was formally divided into 3 districts. A Texas composing the district of Bexar. Legislative power for the state was placed in a unicameral legislature composed of 12 deputies elected by the people, including 2 representing Bexar. Along with the wide-ranging legislative powers, the legislature was also empowered to elect state officials when no majority emerged from the popular vote, to serve as a grand jury in political and military matters, and to regulate the state's army and militia. Executive power was vested in a governor and vice governor, which elected by the people for a 4-year term. Judicial power was placed in state courts. The Constitution of 1827 formally guaranteed the right to liberty, security, property, and equality. Its language also supported efforts to curtail the spread of slavery, an institution of vital importance to planters who were immigrating the American South. The legislature was ordered to promote education and freedom of the press. As in the Mexican Federal Constitution, Catholicism was the established state religion. Political instability in Mexico in the late 1820s and early 1830s largely undercut the provisions and protections of both the federal and state constitutions under which Texans lived. But these constitutions were important to political debate at the time as discontent against the central government built up. At least in the early stages of the Texas Rebellion against Mexico, many Texans could and did see themselves as defending these constitutions as most of the political principles that they represented. The turn away from defending the Mexican Constitution of 1824 and the State Constitution of 1827 to articulating a new constitutional regime relying more on American political and cultural values was fundamental step on the road to independence for Texas. The Constitution of the Republic of Texas, 1836. Texas break with Mexico was in large part Texas break with Mexico was in large part a constitutional crisis that culminated in separation. Americans had come to Texas for a variety of reasons. Some, like Stephen F. Austin, had come in the service of the Mexican state as impresarios, whose goal was to encourage American immigration into Texas by distributing land made available by the Mexican government. They saw themselves as Mexican citizens working with the constitutional regime of 1827. Americans who had come to Texas in the early 1830s still wanted the land and economic opportunities offered by Texas, but they, as part of America's move westward, were far less committed to integrating themselves into the Mexican political community. For these people, separation from Mexico, either as an independent republic or as part of the United States, was the ultimate political objective. Recognizing the dangers to Mexican authority from Americans coming into Texas, Mexican officials made various attempts to limit the influx. These restrictions, along with other grievances, led to growing discontent among Texans over their place in the Mexican federal system. Ultimately, Texans called for political conventions in 1832 and 1833 to discuss new constitutional forms of government. Along with the demands for a more liberal immigration policy for people from the United States and for the establishment of English and Spanish-speaking primary schools, calls for the separate statehood for Texas emerged from the conventions. The 1833 convention actually drafted a constitution and sent Stephen F. Austin to Mexico City to petition the central government for reform. Austin's missions failed and led to his imprisonment, which in turn pushed Texas closer to open rebellion. On November 7, 1835, a meeting of Texas political leaders at San Felipe adopted a declaration stating the reasons Texans were beginning to take up arms against Mexican government. The declaration proclaimed that Texas was rising up in defense of its rights and liberties, as well as the Republican principles articulated in the Mexican Constitution of 1824. But though it was one thing to call for a defense of Republican principles under the Mexican Constitution, it was something else to call for separation from Mexico. In the end, that the declaration was but a prelude to the formal Texas Declaration of Independence that emerged out of the Convention of 1836 held at Washington on the Brazos. Of the 59 delegates attending the Convention of 1836, only 10 had lived in Texas prior to 1830, and 2 had arrived as late as 1836. 2/3 of the delegates, 39, were from southern slave states. 6 were from the border state of Kentucky. 7 were from northern states. 3 were from Mexico, including 2 born in Texas, and 4 from other English-speaking lands. The final products of the convention, the Texas Declaration of Independence, and the Constitution of 1836, reflected the interest and values of these participants. Texas Declaration of Independence. Like the founders during the American Revolution, leaders of the Texas Revolution felt they needed to justify their actions in print. Written by George C. Childress and adopted by the General Convention at Washington on the Brazos on March 2nd, 1836, the Texas Declaration of Independence stated why the signers believed it was necessary to separate from Mexico and create an independent republic. See Appendix A1 through A3. Not surprisingly, the document draws heavily on the ideas of John Locke and Thomas Jefferson for inspiration. The description of the role of the government to protect the lives, liberty, and property of the people repeated verbatim Locke's litany of the primary reasons for establishing government, and like Jefferson's Declaration for the United States, Texas Declaration catalogs a list of grievances against the Mexican regime, which they said failed to provide freedom of religion, a system of public education, and trial by jury. It proclaimed that the federal Constitution regime they had been invited to live under the rulers of Mexico had been replaced by a military tyranny that combined a despotism of the sword and the priesthood. The melancholy collusion of Texas Declaration echoed the ideas that Locke and Jefferson would have understood well. Any government that stripped a people of their liberty was unacceptable to those raised on principles of self-government. Self-preservation demanded eternal political separation from the very state, Mexico, that had invited them to settle in Texas. See Figure 2.1. Here's the Republic of Texas. The provisions and values of the 1836 Constitution. After declaring Texas a separate republic independent from Mexico, the convention proceeded to draft and pass a new constitution reflecting these republican sentiments, resembling the U.S. Constitution in being flexible and brief, fewer than 6,500 words. The 1836 Constitution established an elected chief executive with considerable powers, a bicameral legislature, and a four-tiered judicial system composed of justice, county, district, and Supreme Courts. Powers was divided among these three branches, with a system of checks and balances between them. The Constitution also included complicated procedures for amendments along with the Bill of Rights. The values of American democracy percolated through the documents in other ways as well, such as a guarantee to all white males could vote. Checks and balances were established between the three branches of government. On the other hand, a number of important provisions of the Spanish and Mexican law were adapted for the Texas Republic in the Constitution, including the idea of community property, in which property acquired by either spouse during a marriage would be jointly owned, homestead protections in which one's home would be protected during bankruptcy proceedings, and debtor relief. While giving these Spanish-American legal provisions constitutional status, Texas moved closer to the Anglo-American model of the jurisprudence in other ways. By 1840, the Republic of Texas formally adopted the rules of English common law to replace Spanish law in most civil and criminal matters. But there was one notable exception to following Spanish and Mexican law. Texas initially retained ownership of all minerals under the... go ahead and let me focus in on that so you can write that for your notes. And that's the original Declaration of Independence. Of 1836. ground can even as land grants provided for individual ownership of the land itself. Until the Constitution of 1866, a consensus existed that the best model for developing Texas and its mineral resources was through direct government ownership of all mineral rights. Under the Constitution of 1866, 1869, and 1876, a new model was adopted granting ownership of mineral rights to the individuals who owned the land under which minerals were found. The state retained some claims to mineral rights, largely in western parts of the state, to fund public schools and higher education. But the new idea was that private entrepreneurs would do a better job developing the state's natural resources than would state officials. The complicated history of mineral rights and oil and gas law, as well as in the entire oil and natural gas industry in the 19th and 20th centuries, follows directly from the decisions made in later constitutions to replace the original mineral rights provisions of the constitutions of 1836, 1845, and 1861. One of the most important aspects of the Constitution of 1836, at least from the perspective of newly immigrated Americans from the South, was its defense of slavery as an economic and political institution with constitutional protections. The Constitution of the Cohia y Tejas of 1827 had challenged, albeit unsuccessfully, the existence of slavery. Although the 1836 Constitution outlawed the importation of enslaved peoples from Africa, it guaranteed that slave owners could keep enslaved people as property and that new slave-owning immigrants could bring enslaved people into Texas with them. The result of this constitutional protection were monumental. In 1836, Texas had a population of 38,470, including 5,000 enslaved people. By 1850, the population of enslaved people had grown to 58,161, over 1/4 of the state's population. By 1860, there were more than 182,566 enslaved people, accounting for more than 30% of the population. The Constitution of 1836 not only saved slavery as an institution in Texas, but also provided the protections needed for slavery to flourish. Writing a constitution is one thing, putting it into effect is another. Texas really became an independent state with a working constitution only after the Battle of San Jacinto. I don't know if it's Jacinta or Jacinta, Jacinta, where on April 21st, 1836, Sam Houston's force of 900 men overran the 1,300-man force of Antonio Lopez de Santa Anna and captured Mexican dictator Santa Anna himself. And still many questioned whether the Lone Star Republic would survive given the dismal state of its finances. An army that couldn't protect the Republic's sweeping land claims to the west and the south, a hostile Mexico that only reluctantly accepted Texas secession, and a United States that appeared to be unwilling to bring Texas into the Union. Annexation to the United States in 1845 ended such questions and brought into being a new constitution, this time a state constitution that would operate within the framework of the U.S. Constitution. The Texas State Constitution of 1845. The next phase of Texas founding took place from 1845 to 1861. Although the 1836 Constitution called for annexation by the United States, Texas remained an independent republic for 9 years. The reasons included American concerns that if Texas were admitted to the Union as a slave state, The move could alter the delicate balance between slave and free states and further divide the nation over the sensitive subject of slavery. Additionally, it feared that annexation by the United States would lead to war with Mexico. Santa Anna had repudiated the Treaty of Velasco, which had ended the war between Texas and Mexico thus still claimed Texas as part of its territory. Though both of these fears have proved justified, hesitation over annexation was overcome by the mid-1840s. On March 1st, 1845, the U.S. Congress approved a resolution that brought Texas into the Union as a state. See Appendix pages A5 through A6. The Annexation Resolution had a number of interesting provisions. First, the Republic of Texas created to the United States all military armaments, bases, and facilities pertaining to public defense. Second, Texas retained a right to all its vacant and unappropriated lands, as well as responsibility for its public debts. This was no small matter because Texas claimed an enormous amount of land that extended far beyond its present state boundaries. The boundary issues were not resolved until Congress passed the Compromise of 1850, in which, among other provisions, established Texas' present boundaries in exchange for a payment from the federal government, some of which was used to pay the state's debts. Finally, Texas was given permission to break up into 4 additional states when its population proved adequate. Considerable controversy surrounds this provision, and no serious attempt has been made to put it into effect. On July 4th, 1845, Anson Jones, fourth and final president of the Republic of Texas, called a convention in Austin to draft a state constitution. Drafters of the Constitution relied heavily on the Constitution of 1836. Although the final document ended up being almost twice as long, the familiar doctrines of separation of powers, checks and balances, and individual rights defined the basic design of government. Under the Constitution of 1845, the legislature would be composed by 2 houses. The House of Representatives would have been 45 to 90 members, elected for 2-year terms, and the Senate between 19 and 33 members, elected for 4-year terms. Half of the Senate would be elected every 2 years, as the U.S. Constitution revenue bills would have to originate in the House. In a separate article on education, the legislature was ordered to establish a public school system and set aside lands to support a permanent school fund. Another power granted to the legislature was authority to select the state treasurer and comptroller in a joint session. The Constitution provided for an elected governor and a lieutenant governor. The governor's term was set at 2 years, and a governor could only serve 4 years in any. I'm just focusing in on that so you can see that. In any 6-year period. Among the executive powers granted to the governor were powers to convene and adjourn the legislature, to veto legislation. Vetoes could be overturned by a 2/3 vote of each house of legislature, to grant pardons and reprieves, and to command the state militia. The governor had also had the power to appoint the Attorney General, Secretary of State, and District and Supreme Court judges, subject to the approval of the Senate. The Constitution of 1845 established a judicial branch consisting of a Supreme Court composed of 3 judges, district courts, and lower courts deemed necessary by the legislature. Judges on the higher courts were to be appointed to 6-year terms and could be removed from office subject to a 2/3 vote of each house of the legislature. Amending the Constitution of 1845 was difficult. After being proposed by a 2/3 vote of each house, amendments had to be approved by a majority of the voters and then by another 2/3 vote of each house in the next legislature in order to be ratified. Only one amendment was ever made in 1850, provision for the election of state officials who were originally appointed by the governor or by the legislature. The Constitution of 1861, Texas joins the Confederacy. While slavery had made it difficult for Texas to get into the Union, in the early 1840s, slavery drove Texas from the Union 20 years later. By 1860, slavery concentrated in East Texas along the Gulf Coast had become a vital institution to the Texas economy. However, in large sections of the state, particularly in the north and west, the economy was based on ranching or corn and wheat production rather than cotton. There, slavery was virtually non-existent. The question of whether Texas should secede from the Union along with other southern slave states was a controversial one that divided the state along regional as well as party lines. Pressure to secede mounted following the November 1860 election of President Abraham Lincoln, who was committed to resisting the further expansion of slavery. A staunch Unionist, Governor Sam Houston, refused calls to convene a special session of the legislature to discuss secession. See appendix pages A7 to A10. Seeking to bypass House Houston, a number of influential political leaders in the state, including the Chief Justice of the Texas Supreme Court, called for a special convention in January 1861 to consider secession. Given into the pressure, Houston called a special session of the legislature in the hopes of undercutting the upcoming secession convention. The legislature, however, had other ideas, validating the call for the convention and turning its chambers over to the convention of delegates. Lawyers and slave owners dominated the secession convention, with lawyers composing 40% of the delegates and slave owners 70%. The Texas Ordinance of Secession, produced by the convention on February 2, 1861, reflected this pro-slavery membership. See pages A11 to A12. In striking language, it proclaimed that the northern states had broken faith with Texas, particularly regarding the institution of slavery, and that northerners had violated the laws and Constitution of the Federal Union by appealing to a higher law that trampled on the rights of Texans. The Ordinance of Secession proclaimed, "We held as undeniable," why does it keep going on focus? "Undeniable truths that the government of the various states and the Confederacy itself were established exclusively by the White House for themselves and their posterity, that African race had no agency in their establishment, that they were rightfully held and regarded as inferior and dependent race, and in that condition only could their existence in this country be rendered beneficial and tolerable." Here is the vocabulary words, and then I'll focus it on this picture. Texas voters approved secession from the Union on February 23, 1861. The secession convention then reconvened to enact a new constitution to guide the state as it entered the Confederacy. This constitution was surprisingly similar to the Constitution of 1845, except that the references to the United States of America were replaced with references to the Confederate States of America. Public officials had to declare allegiance to the Confederacy, and slavery and states' rights were defended. A clause in the 1845 Constitution that provided for the possible emancipation of enslaved people was eliminated, and freeing enslaved people was declared illegal. But more controversial proposals, such as resuming the African slave trade, were rejected. The move out of the Union into the Confederacy may have been a radical one, but the new Constitution was conservative insofar as it reaffirmed the existing constitutional order in the state. The Constitution of the 1866 Texas rejoins the Union. Defeat in the Civil War led to the writing of another state constitution in 1866. The provisional governor, pro-Union Andrew Jackson Hamilton, called a constitutional convention on November 15, 1865. A little over 6 months after the surrender of Robert E. Lee's army in Virginia essentially ended the Confederacy's existence. Delegates were elected on January 8, 1866, and the convention was held February 7th under the provisions of President Andrew Johnson's presidential Reconstruction. Few former secessionists were excluded from voting. As a result, the convention was dominated by former secessionists, many of whom held commissions in the Confederate Army. The delegates took a number of actions to bring the state into compliance with presidential Reconstruction, including the rejection of the right to secession. See Appendix A11. A repudiation of the war debt incurred by the state and an acceptance of their abolition of slavery. Formerly enslaved males were granted fundamental rights to their persons and property, as well as the right to sue and be sued and to contract with others. However, they were not allowed to vote and were banned from holding public office. The various amendments to the Constitution of 1861, passed by the convention, came to be known as the Constitution of 1866. As in the two previous constitutions, the size of the House was set between 45 and 90 members, and that of the Senate between 19 and 33. Terms of the office remained the same as under the 1845 and 1861 constitutions. Although salaries were increased, reapportionment was to be based on the number of white male citizens who would be counted in a census every 10 years. The salary was also increased for the governor, whose term was extended to 4 years, with a limit of 8 years in any 12-year period. The governor was also granted for the first time a line item veto on appropriations. The comptroller and the treasurer were to be elected by the voters for 4-year terms. Under the new Constitution, the state Supreme Court was expanded to 3 to 5 judges, whose terms were increased to 10 years and whose salaries were also increased. The Chief Justice was to be selected from among the 5 judges on the Supreme Court. District Court judges were to be elected for 8-year terms, and the Attorney General for 4-year term. Voters ratified the Constitution of 1866 in June in a relatively close referendum, 28,119 to 23,400. The close vote was attributed to a widespread unhappiness with the salary increases for the various state officers. But there were other sources of opposition as well. Many Unionists who had been driven from the state during the war rejected the Constitution, arguing it was the product of a convention dominated by former secessionists. They appealed to the increasingly radical Republican Congress in Washington, D.C. for redress, arguing that former secessionists should be disenfranchised and forbidden from holding office. Their arguments gained force when the first legislature elected under the provision of the Constitution of 1866 passed laws, including black codes, which limited the social, political, and economic status of African Americans in Texas. In response, radical Republicans in Washington passed the Congressional Reconstruction Acts of 1867. Here is the terminology. The Reconstruction Constitution of 1869. Republicans in Congress had come to see the initial efforts of reintegrating Texas and other southern states back into the Union as a failure. Under the direction of Congress, General Winfield Scott, the commander of the Union military force, was still occupying Texas and Louisiana. Summarily dismissed, most state officials elected to office under the 1866 Constitution and called for a new convention to write a new constitution in Texas in 1868. This time, however, former secessionists would be banned from voting or holding office. Against limited Democratic oppositions, radical Republicans easily won the vote to hold a convention by 44,689 to 11,440. Of the 90 delegates to the convention, only 6 had served in the previous constitutional convention. 10 were African Americans. The vast majority represented the interest of various wings in the Republican Party. The convention was a rancorous affair as the delegates argued over a wide range of issues, including railroad charters, lawlessness in the state, and whether laws passed during the war years were legal. In the final days of the convention, delegates finally got down to the constitutional matters and the challenges of accepting the 13th and 14th Amendments to the United States Constitution, which abolished slavery, provided full citizenship to African Americans, and restricted former secessionists from holding office. Although delegates never completed their tasks of reworking the Constitution of 1866, the results of their efforts were published under orders by military officials without being submitted to the voters and became the Constitution of 1869. A number of features of the Constitution of 1869 stand out. The U.S. Constitution was declared to be the supreme law of the land. As in 1866 Constitution, slavery was forbidden. But now African Americans were given the right to vote. 14th Amendments guarantees of the privileges of and immunities of citizens, due process under the law, and equal protection under the law were recognized. Additionally, the Constitution altered the relationship among the 3 branches of government. The House of Representatives was set at 90 and the Senate at 30 members. Senatorial terms were extended to 6 years, with 1/3 of the seats to be elected every biennium. Legislative sessions were to be held annually. The most critical changes, however, were in the executive branch and the courts. The powers of the governor were vastly expanded, among other things. The governor was given wide-ranging appointment powers that included the power to appoint judges. The state Supreme Court was reduced from 5 to 3 judges, and their term was reduced to 9 years, with 1 new judge to be appointed every 3 years. Salaries for state officials were increased. Underlining fueling the debate over the Constitution of 1869 was another deeper constitutional debate about the meaning of the Secession Ordinance of 1861, the Constitution of 1861, and the Texas government that had functioned under the Confederacy. From the perspective of the U.S. Constitution, had Texas ever left the Union? Was the Constitution of 1861 illegal? And what about the laws that had been passed by the legislature under the powers granted by the 1861 Constitution? Were they the law of the land, or did they have no legal force? Were all laws that had been written and all contracts that had been made during the period of rebellion null and void? This debate came to an end with the U.S. Supreme Court decision, Texas versus White, estimated at ETL 1869. Here the court ruled that Texas had never left the Union, which was perpetual and as indissoluble as the union between the original states. The Ordinance of Secession of 1861 and all acts of the legislator that gave effect to the ordinance were considered to be null. See Appendix pages A11 through A12. The first governor under the Constitution of 1869 was Edmund Davis, a Republican affiliated with the radical faction of the party and former Union general. Davis had vast authority since the Constitution had centralized power in the executive while reducing local governmental control. The popular perception at the time was that he presided over a corrupt, extravagant administrative that eventually turned to the state police and the militia attempt to maintain its control. Closer to the truth may be the fact that Davis sought to maintain his rule by relying on formerly enslaved people who had become bulwark of the Republican Party in the state, and by limiting reintegration of former Confederate into state politics. In 1872, the Democrats regained control of the legislature, and in 1873, Democrat Richard Koch was elected governor. Davis attempted to maintain control over the governor's office by having his hand-picked Supreme Court invalidate Koch's election. He refused to give up his office and surrounded himself with state police in the capital. However, when Democrats slipped past the guards and gathered upstairs into the Capitol to organize a government, Davis was unable to obtain federal troops to maintain him in office and finally had to leave. The Constitution of 1876. The final phase of Texas founding began with the passage of the Constitution of 1876. To prevent another government such as Davis, efforts were made to write a new constitution, but in 1874 a proposed constitution was rejected by the legislators. Finally, in 1875, a new constitutional convention was called, with 3 delegates selected by popular vote from each of the 30 senatorial districts. The final composition of the convention included 75 white Democrats and 15 Republicans, 6 of whom were African Americans. Not one of the elected delegates had participated in the Constitutional Convention of 1868 to 1869. 40 of them were farmers and 40 were members of the Grange, a militant organization that had emerged to improve the financial plight of farmers. The document that emerged from this convention of the Constitution of 1876 is still the basis for Texas government today. In an era of agriculture, when prices and incomes were low and when little demand or expected from government, much of in the 1876 Constitution made sense. However, one might question whether a constitution designed primarily by white males for whites in a rural agrarian society, so sorry if I remember, and for the purposes of keeping the likes of Edmund Davis from ever controlling the state again, is the best foundation for government in the modern era. The framers were committed to a constitution with 4 major themes. First, they wanted strong popular control of state government. Second, they believed that a constitution should seriously limit the power of state government. Third, they sought economy in government, by which they meant government would spend as little as possible and as efficiently as possible. And fourth, they sought to promote agrarian interests, particularly those of email farmers, who formed the basis of support for the Grange movement. Popular control of the state government meant that the governor's previously vast appointment powers were limited by making judges and other public officials subject to the election, but did not mean broadening the electorate. When the framers of the 1876 Constitution thought of popular control of government, they thought of control by white males. I'm going to go ahead and zoom on this so that you can see this. Excuse me. And then I'm going to go ahead and zoom on this because it stops at the end of a sentence. Hopefully you can see that. In the effect to limit the powers of the state government, the Constitution placed great restriction on governmental actions, restrictions that could be modified only through a complex constitutional amendment process. Executive authority was diffused among numerous office holders rather than concentrated in the hands of the governor. Although subsequently changed by constitutional amendment as an initial provision, further limited gubernatorial process by setting a 2-year term limit for the office. The legislator was part-time, ordinarily sitting for a prescribed time period every other year. In contrast to the annual sessions provided for in the 1869 Constitution, limiting the power of the state government was accomplished in several ways. The Constitution restricted the extent of government debt and of government's power to tax. In addition, there were limits on the salaries of state officials, especially legislators. A major economic depression had begun in 1873, and many Texans were experiencing economic hardships. One way money was saved was by decentralizing public education. The Constitution provided for racially segregated schools and eliminated compulsory education laws. By gaining local control over education, while landowners could avoid paying taxes for the education of African American students. Texas, at that time, was an agricultural state wishing to protect agrarian interests. The framers, which wrote provisions protecting homesteads from bankruptcy proceedings and restricting institutions that were perceived to be harmful to farmers, such as banks and railroads. There were also detailed regulations on railroad competition, freight passenger rates, and railroad construction incentives. The Constitution of 1876 was a conservative document that, with a distinctly populist flavor. On the other hand, it broke with the more activist government model laid out by the two Reconstruction Constitutions of 1866 and 1869. On the other hand, it sought to protect those being harmed by the social and economic changes that transformed Texas after Reconstruction. The debates of the Constitutional Convention of 1876 drew attention to the fact that Texas was undergoing rapid change. New social and economic conditions, particularly the aggregation of capital and in immense railroad systems, gave rise to new social and political problems. These in turn demanded the institution of new restrictions on the powers of the state government to prevent corruption, a new constitution with new provisions that restricted the activist of government became the bulwark of a conservative white social and political order in the state throughout the late 19th and early 20th century. See Governor Richard Coke's inaugural address in 1876, appendix page 813. Even in its earliest stages, a Texas Constitution of 1876 was a lengthy, rigid, and detailed document, and purposely so regulations curtailing government power were placed not in the statutes where they could easily be reversed, but in the body of the Constitution. The goal of this design was to ensure the radical Republicans and Edmund Davis would never again be able to control the state. They never did, although over the years the Constitution became increasingly unwieldy. Document Table 2.1. I'll go ahead and close in on that so you can see that. And I'm also going to close in on the Table 2.2. Hopefully you can see that. It takes up the whole page. Here's the terminology for the next section. Excuse me. The Constitution of Texas today. Analyze the major provisions of the Texas Constitution today. The U.S. Constitution has two great virtues, brevity and flexibility. Neither of these can be said to the characteristics of the Texas Constitution. The U.S. Constitution is limited to 7 short articles and 27 amendments. Much in the federal document is left unsaid, allowing lawmaking to be accomplished by the statute. In contrast, in 2020, the Texas Constitution contained 16 articles, see Table 2.3. Another article that concerned Spanish and Mexican land titles was deleted from the Constitution in 1969. 690 amendments have been proposed by the legislature. 507 have been approved by the electorate, while 180 have been defeated. Curiously, 3 amendments were proposed by the legislature, but for the obscure historical reasons never voted on by the electorate. Many of the articles are lengthy, complex affairs, but it is not just the length that differentiates the two constitutions. There is a difference in tone. The Texas Constitution reflects the writer's fears of what government could do if the principle of limited government was not clearly established. In addition to its severe limits on executive power, the Texas Constitution also addresses a number of specific policy problems directly in the text, turning what might appear to be matters of public policy into issues of constitutional authority. By granting a variety of boards and districts a special place in the Constitution, the framers created additional checks and balances that make it difficult for governors to exercise power effectively. Quite unintentionally, the Texas Constitution became a place where special interests could promote and protect their own agendas. Even in the face of considerable political opposition, the contrasts in character between the federal and Texas Constitution are a direct reflection of the differences in their framers. Underlining Goals. The U.S. Constitution was written to overcome the liabilities of the Articles of Confederation and create a government that could act effectively in the public welfare in a variety of policy areas. The Texas Constitution was written to prevent expansion of governmental authority and the return of a system of political power that was perceived as acting against the interest of the people. Here's the chart of Table 2.2. These are the different articles overview. And then here's what Texas thinks. Sorry. Sometimes I act too quickly. The Preamble. The Preamble to the Texas Constitution is surprisingly short, humbly invoking the blessings of Almighty God. The people of the state do ordain and establish this Constitution. This brevity is more than made up for in what follows. Article 1, Bill of Rights. Article 1 of the U.S. Constitution establishes and delegates power to the legislative branch. One of the overriding concerns of the founders was to create a legislature that could act effectively in public affairs, what came to be known as the Bill of Rights. The first 10 amendments to the Constitution was added after the original Constitution was drafted and approved. In it, I don't think that's part of it. I'm sorry. Approved. How should we balance? Okay. I'm so sorry. Sometimes I get lost. How should we balance civil rights and religious freedom? Constitutional protections can clash with one another. The right to practice one's conservative religious beliefs can come into conflict with the civil rights of another person. To get married in Texas, Democrats, Republicans, and self-identified members of the conservative Tea Party movement disagree sharply on how these protections should be balanced with one another. In the context of controversies around same-sex marriage and transgender rights, a recent poll in Texas respondents to evaluate the following statement. In contrast, the Texas Constitution puts its Bill of Rights up front as Article 1. Well before any discussion of legislature, the executive, or the courts, from the beginning, the purpose of the Texas Constitution was not simply to create a set of institutions that could wield political power. It was to limit the way the political power is used and prevent it from being abused. Section 1 of the Bill of Rights proclaims that Texas is a free and independent state, subject only to the Constitution of the United States and the maintenance of our free institutions, and the perpetuity of the Union dependent upon the preservation of local self-government, unimpaired to all the states. On the face of it, this proclamation would seem to be relatively non-controversial, as it appears to accept the Constitution of the United States and the perpetuity of the Union put into proper historical context. However, it meant something very different. The Constitution of 1869, written under the watchful eyes of radical Republicans in Texas and the U.S. Congress, had rejected the heresies of nullification and secession, and explicitly acknowledged that the U.S. Constitution was the supreme law of the land and that Texas Constitution was subject to national authority. Article 1, Section 1. The product of the Constitutional Convention in 1876 was hostile to many of the efforts of Reconstruction, concedes two very different things. One, that Texas is free and independent, subject to the U.S. Constitution, and two, that free institutions and perpetuity of the Union depend upon local government, self-government, that is unimpaired. No mention is made of the supremacy of the U.S. Constitution over the state constitution. Here's the idea of the perpetual union is made to depend upon the preservation of local self-government. meaning an independent and autonomous state government freed from an intrusive national authority. Texas may have lost the Civil War, but Article 1, Section 1 claims an autonomy of the state from outside forces that would have surprised many politicians outside the state. Such sentiments continue to resonate throughout parts of Texas today. The Texas Bill of Rights embodies certain ideas captured in earlier state constitutions, and the U.S. Bill of Rights, all free men are declared to have equal rights. Section 30, that cannot be denied or abridged because of sex, race, color, creed, or national origin. Section 3A, freedom of religious worship is guaranteed. Section 6, and religious tests for office are prohibited. Section 4. Liberty of speech and liberty of the press are guaranteed. Section 8. Individuals are protected from unreasonable search and seizure of their homes and property. Section 9. From excessive bail. Section 11. From bills of attainder, imposing punishment for an action without holding a trial, and ex post facto laws, making an action into a crime retroactively. Section 16, and from double jeopardy, being prosecuted twice for the same crime. Section 14. Article 1 also guarantees an individual a right to trial by jury. Section 15, and the right to bear arms in the unlawful defense of himself or the state, but the legislator shall have the power by law to regulate the wearing of arms with a view to prevent crime. Article 1, Section 23. Article 1 also contains some ideas that move beyond those guaranteed by the first 10 amendments to the U.S. Constitution. The right to Republican government, something clearly stated in the main body of the U.S. Constitution, but not in the U.S. Bill of Rights, is powerfully articulated in the first two sections of Article 1. The sections declare that all political power is inherent in the people, and that the people of Texas have at all times the inalienable, I cannot pronounce that word, right to alter, reform, or abolish their government in such a manner as they may think expedient. Article 1, Section 2. The differences between the Texas Bill of Rights and the U.S. Bill of Rights are not simply matters of where best to articulate a philosophy of Republican government. They also involve very concrete matters of public policy. Section 26 of the Texas Bill of Rights, for example, forbids monopolies that are contrary to the public interest and states that the law of primogeniture and entail, a law designed to keep large landed properties together by restricting their inheritance to the firstborn child, will never be in effect in this state. Although monopolies remain a public concern today, primogeniture and entail are not. Section 11 in the Texas Bill of Rights grapples with the complicated issue of bail and under what specific circumstances an individual can be denied significantly. Section 11 has been the subject of three major constitutional revisions. In 1955, 1977, and 1993, Section 30, adopted in 1989, provided a long list of the rights of crime victims, including the right to be treated fairly with dignity, the right to be protected from the accused, and the right to restitution. Although these are important matters of U.S. public policy for Texas today, they could hardly be considered proper material for the U.S. Constitution. Article 2, the powers of government. Like the U.S. Constitution, Article 2 divides the power of government in Texas into three distinct branches: the legislative, the executive, and the judicial. It also stipulates that no one in any one branch shall be attached to either the other branches, except where explicitly permitted, as the case of the lieutenant governor's role in the Senate. The article, one short paragraph of text, assures that a version of the separation of powers doctrine found in the U.S. Constitution will embodied in Texas institution. Article 3, Legislative Department. Article 2 is one of the shortest articles in the Texas Constitution. Article 3 is the longest, making up almost 1/3 of the original text of 1876. Like Article 1, the U.S. Constitution, Article 3 of the Texas Constitution vests legislative power in two houses: a Senate of 31 members and a House of Representatives of no more than 150 members. It stipulates the terms of office and qualifications. House members serve 2-year terms, whereas senators serve 4-year terms. Half being elected every 2 years, House members must be citizens of the United States, must be at least 21 years of age, and must have resided in the state for 2 years and in their district for 1 year. Senators must be citizens of the United States, must be at least 26 years old, and must have resided in the state for 5 years, and in their districts for 1 year. In addition, Article 3 provides for the selection of officers in both houses of the legislature, states when and for how long the legislature shall meet, Section 5, and explains how the legislative proceedings will be conducted, Sections 29 to 41, and how representative districts will be apportioned, Sections 25, 26, and 28. Like Article 1, Texas Bill of Rights, Article 3 moves well beyond the U.S. Constitution, putting limits on what the legislature can do. For example, it puts limits on legislators' salaries and makes it difficult to increase those salaries. Article 3 also creates a bipartisan Texas Ethics Commission, whose job, among other things, is to recommend salary increases for members of the legislators and to set per diem rates for legislators and the lieutenant governor. Article 3, Section 49A also subjects the legislator to the actions of the comptroller to public accounts, whose duty is to prepare a report prior to legislative session on the financial condition of the state treasury and to provide estimates of future expenditures by the state. The provision of Texas Constitution effectively limits the state legislature to the financial calculations and endorsements of the comptroller, a check on the legislature all but unimaginable to the writers of the U.S. Constitution. Putting constraints on certain legislative actions is only part of the story. The largest portion of Article 3, Sections 47 to 64, is dedicated to addressing a variety of policy issues, including lotteries, emergency service districts, debt creation, the Veterans Land Board, and Texas Water Development Board, Texas Park Development, the creation of a state medical education board, and even the establishment of an economic development fund in support of the new defunct superconducting super collider. Article 4, Executive Department. Article 2 of the U.S. Constitution concentrates executive power in the presidency. Under the U.S. Constitution, cabinet members such as Secretary of State, the Attorney General, and the Secretary of Agriculture are appointed by the President and confirmed by the Senate. Executive power is vested or placed in the hands of the President. See U.S. Constitution, Article 2, Section 1. Vested executive power in this regard is broad-ranging term that covers wide range of activities. The goal of the framers was to create a more effective and more responsible executive than had been possible under the Articles of Confederation. Here's the vocabulary word for this. Sometimes it gets real blurry. I'm so sorry, guys. I don't know why it does that. There we go. In contrast, there is no vesting of the executive power in any one executive office in Texas. See Table 2.4. Article 4 of the Texas Constitution states that the executive shall consist of 6 distinct offices: the governor, who serves as the chief executive; the lieutenant governor, who serves as the president of the Senate; the secretary of state, who keeps the official seals of the state; the comptroller of public accounts; the commissioner of the general land office; and the attorney general. Attorney general, who acts as the state's chief legal officer, with the exception of the Secretary of State, who is appointed by the governor and approved by the Senate. All other officers are elected by voters every 4 years. Besides creating a plural executive, see Chapter 8, Article 4, guarantees its members will have independent political basis in the electorate. This arrangement provides an additional check against any concentration of powers in the hands of any person. Article 5, Justice Department. Oh my goodness gracious. I'm so sorry, guys. Article 5, Judicial Department. Article 3 of the Constitution of the U.S. Constitution successfully provides for the Supreme Court and empowers Congress to create any necessary lower courts. As such, it could not be further from the detailed discussion of the state courts found in Article 5 of the Texas Constitution. Besides creating a Supreme Court to hear civil cases and a Court of Criminal Appeals to hear criminal cases, Article 5 provides such lesser courts as the courts appeal, district courts, commissioners, courts, and justice of the peace courts, and empowers the legislature to establish other courts as deemed necessary. It also goes into such details as the retirement and compensation of judges, the jurisdiction of the various courts, and the duties of judges. It states what to do in the case of court vacancies, and it includes a series of discussions on particular issues involving the lower courts. An even greater difference between the federal and Texas Constitution in their treatment of the judiciary is the crucial role Texas gives to elections. Federal judges are appointed by the president and approved by the Senate. In Texas, the people elect state judges, 9 Supreme Court and 9 Court of Criminal Appeals judges are elected at large in the state, and lower court judges are elected by voters in their respective geographic locations. Much like the U.S. Constitution, the Texas Constitution seeks to create an independent judiciary that can check and balance the other 2 branches of the government. However, it seeks an additional check as well, in that it wants the people to, in turn, watch over the courts. Article 6, Suffrage. Article 6 contains a short but detailed discussion about who may vote in Texas. It also empowers the legislature to enact laws regulating voter registration and the selection of electors for the president and vice president. Article 7, Education. The concerns found in the Texas Declaration of Independence over the need for public schools to promote Republican form of government are directly addressed in Article 7 of the Constitution, which declares a general diffusion of knowledge essential to, I'm sorry, there's like 3 graphs is what threw me off. Here's this one. Hoping that's close enough so that you guys can see that, and pause it. The preservations of the liberties and the rights of the people, Section 1 makes it a duty of the state legislature to support and maintain an efficient system of public free schools. The Texas Supreme Court's interpretation of the provision as applying to school funding in the state has led to political battles over school finance for 40 years. Section 2.8 provide for the funding of public education and the creation of a state board of education to oversee the operations of elementary and secondary education. Article 7 also provides for the establishment and funding of a university of the first class to be called the University of Texas, as well as an agricultural and mechanical college, Texas A&M University. Provisions were later included to fund other state universities and colleges. State universities are subject to over half of Article 7, where detailed discussions of the funding and operations of particular state institutions are put directly into the text. Article 8, Taxation and Revenue. The complex issue of taxation in the subject of Article 8, where once again we find a highly detailed account of several important policy issues built directly into the text of the Constitution. One of the most controversial sections of the Texas Constitution during the 2019 session centered on the issue of income tax. Section 1 of Article 8 of the 1876 Constitution enabled the legislature to tax the income of individuals and businesses. But as we will discuss in the Citizen's Guide to this chapter, the legislature refrained from doing so. In 1993, a constitutional amendment was passed, Article 8, Section 24, which required that a personal income tax to be approved by the voters, and that the proceeds from its dedicated to education and tax relief. In 2019, Article 8, Section 24 was replaced by another amendment which repealed Section 24 entirely by prohibiting any income tax on individuals. As with other portions of the Constitution, the net effect of Article 8, Section 21A provisions was to curtail severely what the state legislature can do and how it can do it. If Section 24A of Article 8 is any indication of public fear of unresponsive and potentially tyrannical government, is as alive today as it was in 1876. Articles 9 and 11, Local Government. These articles provide highly detailed divisions of the creation, organization, and operation of counties and municipal corporations. I'm going to go ahead and, because it stops there, an FYI, if I remember correctly, yes, Texas is the second longest state constitution, just so, in case that's a question on the test. And I can't see which one. There's one that has the longest. I think it's Georgia, but don't quote me on that. Oh, it is. It's Alabama. One state off. There you go. In case that's a test. Question on a test. Articles 10, 12, 13, and 14. These heavily revised articles deal with a series of specific topics. The railroads, 10, private corporations, 12, Spanish and Mexican land titles, 13, and public lands, 14. Article 10 empowers the state to regulate railroads and to establish the Railroad Commission. Article 12 empowers the state to create general laws creating private corporations and protecting the public and individual stockholders. Article 13, now entirely repealed, dealt with the 19th century issue of Spanish and Mexican land titles. Article 14 created a general land office to deal with the registration of land titles. Article 15, impeachment. Go ahead and sometimes it'll, there we go. Sorry about that. Article 15, impeachment. In the U.S. Constitution, impeachment is one of the major checks Congress holds against both executive and judicial branches of the government. The House of Representatives holds the power to impeach an individual. The Senate is responsible for conducting trials. 2/3 vote in the Senate following impeachment by the House leads to the removal of an individual from office. A similar process is provided for in Article 15 of the Texas Constitution. The House has the power to impeach. The Senate has the power to try the governor, lieutenant governor, attorney general, land office commissioner, and comptroller, as well as judges of the Supreme Court. The Court's appeal and district court's conviction requires a 2/3 vote of the senators present. In contrast to the U.S. Constitution, the Texas Constitution rules that all officers against whom articles of impeachment are proffered are suspended from their office. The governor is empowered to appoint a person to fill the vacancy until the decision on impeachment is reached. Despite these similarities to the impeachment procedures in the U.S. Constitution, the Texas Constitution has its own caveats. Most notably, the Texas Constitution does not explicitly define impeachable offenses in terms of treason, bribery, or other high crimes and misdemeanors, as the U.S. Constitution does. The House and Senate and the courts decide what constitutes an impeachable offense. In addition, the Supreme Court has original jurisdiction to hear and determine whether district court judges are competent to discharge their judicial duties. The governor may also remove judges of the Supreme Court, Courts of Appeal, and district courts when requested by the 2/3 vote of each branch of legislature. Significantly, the reasons for removing a judge in this case need only involve a willful neglect of duty, incompetence, habitual drunkenness, oppression in office, or other reasonable cause. Article 15, Section 8, the barriers to removing a judge by political means are thus, at least on paper, much lower in Texas than in the national government. In 1980, Section 9 was added to Article 15, providing a new way to remove officials appointed by the grievance. With the advice and consent of 2/3 of the members of the Senate present, a governor may remove an appointed public official if the legislature is not in session. The governor is empowered to call a special two-day session to consider the proposal for the proposed removal. Article 16, general provisions. Article 16 is one of the lengthiest in the Texas Constitution and has no parallel in the U.S. Constitution. It is laterally a catch-all article tackling a variety of issues ranging from official oaths of office to community property to banking corporations and stock laws to the election of the Texas Railroad Commission to the state retirement systems. Here, perhaps more than anywhere else, we see the complexity and confusion of the philosophy reflected in the Texas Constitution. Article 17, amending the Constitution. Like the U.S. Constitution, the Texas Constitution explicitly delineates how it can be amended. Essentially, to be adopted, an amendment must undergo a 4-stage process. First, it must be proposed by the legislature meeting in either regular or special session. Second, it must be approved by 2/3 vote of all members elected to each house. Third, a brief statement explaining it must be published twice in each recognized newspaper in the state that meets the publication requirements for official state notices. Finally, it must be approved by a majority of the state's voters in a statewide election. Recent attempts to rewrite the Texas Constitution. Describe the efforts to change the Texas Constitution. Given the difficulty of amending the state constitution, a surprising number of amendments have been proposed by the legislature and approved by the people. By 2019, 690 amendments had been passed by the legislature, and 507 had been adopted. Following a major stock fraud scandal in the 1970s, there was an attempt to rewrite the entire Constitution by calling a constitutional convention in 1974 that lasted 150 days. Bitter politics, coupled with the intense demands of highly mobilized special interests, made it impossible to reach an agreement. In the end, proponents of a new constitution failed to achieve the necessary 2/3 majority by 3 votes, 118 to 62, with one abstention. Attempts to rewrite the Constitution through 8 constitutional amendments in 1975 failed, as well as the voters rejected all 8 in special election in November of 1975. Demands for amending the Constitution have intensified in recent years as legislators have dealt with the problem of making changes in public policy while being constrained by an unwieldingly unconstitutional document. Recent amendments. One thing is clear about the Texas elections dealing with the constitutional amendments is that voting participation is invariably low. Who Are Texans on page 71 compares the percentage turnout registered voters in November special elections on constitutional amendments with the percentage turnout in presidential elections, which tend to produce the highest turnout. There are two likely reasons for the low voter turnout in constitutional amendment elections. First, constitutional amendment elections are usually held in off years, following the general session of the legislature, and most special sessions when there are no elections with candidates on the ballot. Without candidates to generate voter turnout, the political parties take a less active role in getting out their voters as a result. Advertising campaigns about the election are frequently limited to those of interest groups that support or oppose the issues on the ballot. Second, many of the amendments are relatively insignificant to most voters. While most proposed constitutional amendments are uncontroversial, such as not in the case in 2011 when 3 out of 10 amendments presented to the voters were turned down. The controversial ones were those that the Tea Party and other anti-tax groups saw as increasing the financial burden on Texas. For example, Proposition 4 was defeated because it would have expanded the ability of counties to issue bonds to finance the development of unproductive areas, where those bonds were to be repaid with property tax revenues. Critics of the proposal argued that it would clear the way for new toll roads. Proposition 7 was defeated because it would have given El Paso new borrowing authority. Proposition 8, which passed the legislature with bipartisan support, was defeated because it would have given property owners the opportunity to opt out of agriculture or wildlife conservation property tax exemptions in favor of water conservation property. It's stopped in the middle of the sentence again. I'm sorry about that. I hope you can see it. There we go. And then here's for this. Tax exemptions. The Tea Party successfully opposed the proposition on the grounds that it would shift the tax burdens to others, while Tea Party and other anti-tax groups could not defeat all the propositions they opposed. Low voter turnout enabled them. Sorry about that. While the Tea Party and other, it keeps getting blurry on me, other anti-tax groups could not defeat all the propositions they opposed. Low voter turnout enabled them to exert a significant influence. Indeed, their defeat of the three proposals broke the modern-day pattern in which amendments are routinely approved. For example, between 2001 and 2010, 77 of 79 proposed amendments were approved. In the 2019 constitutional amendment elections, voters were asked to consider 10 proposed amendments. 9 of the 10 amendments passed. See Table 2.5. The one that failed was a minor proposition enabling people to hold more than one municipal judgeship at a time. 12% of the registered voters went to the polls, 6% higher. 6 percentage points higher than the 2017 constitutional amendment elections. Still, turnout was far behind the 2016 presidential elections, when 59% of the voters turned out, or 2018, when 53% of the registered voters turned out to vote in a toughly fought senatorial campaign. Participation in the 2005 constitutional amendment election may appear to be abnormally high. See Who Are Texans on page 71. Most of the 2005 proposed constitutional amendments were like the previously discussed propositions or of significance only to a narrow group of people. For example, one of the 9 proposed amendments provided for clearing land titles in Upshur and Smith counties. Another authorized the legislator to provide for a 6-year term for a broad member of Regional Mobility Authority. Yet the turnout in this election was much higher than is typically seen in constitutional amendment elections. The reason was Proposition 2, which defined marriage in Texas as the union of one man and one woman. The proposition also prohibited the state or any political subdivision of the state from creating or recognizing any legal status identical to or similar to marriage. The proposition generally generated a strong favorable vote, 1,723,782 in favor versus 536,913 against. Unlike Proposition 12 in 2003, this was not an economic battle involving interests concerned with tort law. Rather, this was an issue pitting social conservatives against those more sympathetic to gay rights. The strength of social conservative votes in the state was, of course, remarkable, since the amendment carried by more than 3-to-1 margin. Many churches and religious organizations strongly supported the proposed amendment. Their activities probably generated the relatively high voter turnout. The proposition was unusual in that people felt it was important to their lives because it affected their value systems. Although it is doubtful the amendment was necessary to support the traditional concept of marriage, and although the ambiguity of the provision rejecting any legal state status similar to marriage is disturbing, a significant part of the voting population apparently believed that it was important to vote their moral values, even if the proposal was largely symbolic. Although most constitutional amendments are not of great importance, there are some notable exceptions. Table 2.6 identifies some of the amendments that, like Proposition 12 in 2003 or Proposition 2 in 2005, have had significance in public policy. Hopefully you can, there we go. I can read that perfectly. So you can pause that and read that, some of the important. And then here is the Citizen's Guide. Sometimes I'll kind of zone in. And then here is the conclusion. Sorry it's so long, guys. The Constitution and the Future of Texas. In this chapter, we explored the Texas founding and the story of constitutional government in Texas. We analyzed the 7 constitutions under which Texas has been governed and explained the similarities and differences between the U.S. Constitution and Texas' current Constitution of 1876. We also discussed successful attempts to amend the Constitution and some of the constitutional issues that face Texas today. It has been decades since there was any serious effort to change the Texas Constitution in any way other than by adding to its numerous amendments. This pattern likely will continue. More and more amendments will be added to an already lengthy and cumbersome document. Many of the amendments will address technical problems often related to the operations of various state agencies and local governments. Some may create additional funding sources for major state initiatives, as we have seen recently in water and transportation policy. Other amendments might be adopted in response to such controversial social issues such as abortion or the free exercise of religion. Turnout in constitutional amendment elections will remain low unless there is a highly controversial amendment on the ballot. Though narrow interests have outsized influence on the proposing and passage of constitutional amendments, the Constitution and its amendments will continue to reflect the values and goals of the people of Texas and the political system that the people have put into place through the Constitution. This is the end of Chapter 2, the Texas Constitution. Thank you.